Item number 1.
Well, it's towards the order dated 12/6/2025, a fresh report has been filed by the state, Millards. And it's a committee, as directed by this Honorable Court, has been formulated by the state. However, my lords, there is one issue that would be important in this matter. A certain locality of Shillong, my lords, which is called as Lao Sotun. My lords, there has been large-scale felling of trees. My lords, we wanted to bring that on record. So we are in the process of, my lords, filing an appropriate application. My lords, I was praying if your lordships kindly accommodate us for today, and this matter is kindly taken up any time.
Let us see the report,
My lords. My lords, may kindly have a look at page 1, my lords, paragraph 2.
Yes, Mr. Paul, what is the subject matter of your application?
Well, there is an area called Lausatun. There was a newspaper report that an entire forest has been cleared off in recent times. We visited the site yesterday, and we've taken photographs of the area. A huge number of trees have been felled, and it's been recently felled. From the site, we can understand it's been recently felled. This does not find mention in the report as well.
Already felled?
Yes, as a matter of fact, the caption in the Shillong Times read as the green cover of that particular area is completely lost.
What is the area?
Lausatun,
You can get it. It's in which district?
Well, it is in East Khasi Hills district. It's in Shillong, It's one of the localities of Shillong.
We will take note of it and permit you to file the application by course of today.
I'm obliged.
What we have done, they found
This side. This side. Towards Lumbari side. Towards Lumbari. I've seen that order. No, it's not in the army side. It's towards Lumbari side.
We will ask them to make a
We'll have it, sir. We'll see.
Left.
random check inquiry.
Left side. Not the right side. Right side would be the army.
Thanks.
What is the caption?
Paragraphs 1, 2, 3. Of the order dated 12 June 2025. On 12 June 2025, when this application once again appeared in our list for consideration, we noted that no report had been filed by the state Full stop. We adjourn this application till today to receive a report. Paragraph. A report has been filed. Paragraph. Before we refer to the report, we express our deep concern hearing the submission of Mr. Paul, learned senior advocate, appearing for the petitioner, that in so-and-so area of East Khasi district, there has been indiscriminate large-scale felling of trees,
Date on the report,
comma, so much so that
till the date.
the entire environment of the place has undergone a change. Paragraph. We direct the petitioner to file an affidavit in course of today, bringing on record the above fact. Full stop. Relying on the submission of Mr. Paul, to be supported by the said affidavit to be filed, we take suo motu cognizance of this fact. Paragraph. We have perused the report of the state government dated 20th June 2025. According to this report, a state-level committee comprising of the Chief Conservator of Forests, bracket T, Meghalaya, Shillong, I've said state-level committee.
Yes.
Huh? And after that you write, comprising of 3 members, namely Chief Conservator of Forest, bracket T, Shillong, as chairman, Dr. Krishna Upadhyaya, Associate Professor, bracket Environment Science, Department of Basic Sciences and Social Sciences, Northeastern Hill University, Shillong, and Secretary Forests and Environment Department, Government of Meghalaya, as members, has been constituted to implement our orders to stop illegal felling of trees, paragraph. On perusal of this report, we find that the committee has made large-scale delegation of duties and responsibilities to the district, no, DFOs, divisional
forest office.
forest officers and has till date taken little or no action themselves. Full stop. For example, the committee has classified the trees mentioned in various applications for felling. The trees for felling mentioned in various applications as dead trees, trees which are not dead and which could be preserved by quotation lopping of some branches. Dead trees and either the committee has taken on record the opinion of the divisional forest officer that a particular tree is dead or needs lopping up of branches within quotation, or it has directed the said officer to classify the state of the trees in that respect and furnish a report before the committee. Full stop. However, the committee has reserved the right to cross-check these reports by the divisional forest officer. Next, this will not do, full stop. The committee has to make a random, the committee has to make visits and do random checking of trees so certified by the divisional forest officer, and on that basis issue further directions or itself take a decision in the matter? Like a random, what have I said?
Random.
Paragraph. Furthermore, the committee is directed to immediately call for a report from the concerned divisional forest officer with regard to the allegation of the petitioner made today with regard to, not with regard to, concerning large-scale illegal felling of trees in blank area. Till this exercise is completed by the committee, it shall not permit any felling of trees or even quotation lopping up of branches unless it is absolutely satisfied that the condition of the tree is such that it poses an imminent danger to life and property. Life or property or both. What is that?
What would you say?
Tree may be permitted. Tree may be permitted.
The respondents are directed to file a further status/action taken report in this court by 18 July. List is with a copy served on the advocate on record for the petitioner. List is public interest litigation once again on 22nd July.
Millets, photographs from that particular area have just come in, Millets.
You
Find it in the application, Millets, lordships have already taken cognizance. Now, what
Yes.
can be seen from here is, Millets, a huge tract of land has been cleared.
We have recorded your submission.
May I just pray, Millets, that if there's any further felling of trees may be stopped, if at all it is going on, Millets.
We have said so.
Millets.
No felling and no lopping also.
Millets.
Unless it's an imminent danger to life or property.
Millets.
And we will have instruction, your lordship. So far that
Seems a very lush green area has, Millets, completely been made barren.
You, apart from the court order, you also see to it that
Lordship,
this
yes.
kind of the natural
lordship, yes, it is a lifeline, your lordship.
habitat of this place is not changed like this.
Only your lordship will the dead tree, your lordship will permit us to cut the dead tree. Your
Sorry?
lordship. The dead trees, your lordship. There is a lordship in the report, your lordship.
Let the committee first verify. It is very easy to say it is dead. Let the committee, we are saying you do spot checking. If they find it is dead, well and good.
Lordship. Apply, your lordship.
Number 2.
Please, your lordship. By my lord's order dated 26 February, my lord has requested the district and session judge here in Shillong, my lord, to find out the excess amount of payment on the basis of the report submitted. I think the report has come, my lord. The order has come, my lord.
Yes. The thing is not excessive.
My lord, we did not get the order of this
Milord, this report, whatever has come before your Lordship, it has not come to us till now. Milord, in my limited understanding, Milord, the matter was sent as a reference to the reference court. So the directions of the Honorable Supreme Court, whatever the Supreme Court wanted, that has been complied with. And now, since the reference court has arrived at a finding that would amount to a judgment or a decree, whatever, and the parties can have legal recourse against that independently, I think the proceedings before this Honorable High Court, probably in this instant proceedings, probably may be closed. Because...
So what was the issue involved? Please remind us.
My Lord.
I'll just, this is the issue framed by the Honorable Supreme Court. I'll just read out, my Lord. It says the Honorable Supreme Court had framed this issue, my Lord, while requesting His Lordship's, my Lord. The only other issue which survives is, number one, whether the public money has been squandered as suggested by offering high rate of compensation, which is against the rate offered by the owner and the rate at which she purchased just before the acquisition. So, she bought 2 lands. Admittedly, the finding is that 11 rupees she paid per square feet, 50 rupees she paid per square feet before the acquisition. Initially she offered for 50 rupees per square feet, which is, again, nobody, my Lord, will offer, I bought a land for 52 rupees and I'll offer to the government 50 rupees. Not possible. Subsequently, then she raised it to 115 rupees. And that 115 rupees is exactly the tally amount with the district magistrate's submission, my Lord. So
The land was not acquired.
no, the land was, my Lord, the land was
Private treaty,
yes.
private contract
Private.
with the government.
No, it was an acquisition, Milord. Acquisition and advance payment was made, Milord. That urgency clause was invoked
Under the Land Acquisition Act.
under the Land Acquisition.
Yes.
Under the Land Acquisition Act. Proceedings were under the Land Acquisition Act.
For the Shillong airport.
Yes, my Lord.
Milord, what happened, Milord, when the Shillong airport extension was being done, some land was taken from the army authorities. There is some army cantonment nearby. So army had given some land on the understanding that army will not be compensated in money, but will be given some more land in exchange. So in exchange for giving that land, an acquisition proceedings was done and land was acquired for handing over to the army. So it has been acquired and it has been handed over to the army. So that acquisition proceedings is the matter of this instant proceedings.
Public interest litigation.
But it was not a public. What happened, Milord? Aggrieved parties, some aggrieved party went to the Supreme Court, and the Supreme Court reopened the matter, requesting this Honorable High Court to institute an inquiry by the district judge. So, inquiry initially was done by the district judge at Nongpo. So, when the Nongpo court did the inquiry and submitted the report, thereafter your lordships were pleased to observe that justice will not be done unless a proper reference is done. So, your lordship directed that the matter be sent for reference to the Shillong court, Shillong district judge. So, in Shillong district judge, the matter was taken up and now the report has been given. So, what I understand is that this basically needs to be a judgment against which, Milord, proper relief, whatever may be available in law, Milord, the persons may be at liberty to exercise. And this instant proceedings, Milord, I submit that probably it has been, Supreme Court's direction has been complied with and the proceedings have come to a close.
No, but when the Supreme Court has said that the court will make an inquiry, now suppose an appeal is preferred and this whole order is reversed and the appellate court says that no, 115 rupees is very high, so there must have been some wrongdoing between the owner and the government. Then what the court will do? It has already closed the matter.
Yes.
Milord, then the appellate court, Milord, appellate court will be this Honorable High Court only, Milord, probably. So the appellate, in its appellate jurisdiction,
the Supreme Court pursuant to Supreme Court's order, this public interest litigation has been started. So the Supreme Court will look towards the outcome of this litigation.
See, the other.
So whom are you representing, Mr. Chakraborty?
I'm one of the claimants. We are all claimants.
Claimants means?
They're interested in the land. We have interest in the land, and that's why we have filed our claims for being compensated.
My lords, what had happened is, when the land was acquired, my lords, 80% of the compensation money, as is required under the Act, was paid to us. Now, thereafter, some of the aggrieved parties had gone to the Supreme Court. Then the Supreme Court had passed the order, asking the court to cause an inquiry and look into the matter if any excess compensation has been paid and whether public money has been squandered or not. Now, thereafter, my lord, the inquiry was held, and the findings are before my lords. Now, my lord, we are yet to receive a copy of what is the finding of the reference code, my lord.
No, but who are the other stakeholders?
My lord, I am representing one of them, my lord.
The original landowner.
He's the claimant number one. I'm claimant number two. No,
He's number two.
I'm
number
claimant
three.
He's number three. Three claimants are there before the district judge.
If I may submit, there are two aspects before the Honorable Supreme Court. One was whether excess compensation has been paid, and second is who is entitled to compensation among these three men. Claimant number 1, 2, and 3. Now, what I believe, my lord, on reference, the learned district judge has said, though I don't have a copy, my lord, that there is no excess payment of compensation. So that public interest aspect has been taken care of, my lord. Now, the second question, this is in the realm of private dispute, my lord.
Who is entitled to
Who is
compensation?
entitled, among these three, who is entitled to compensation?
What is their relationship?
My lord, they claim to be landowners.
My lord, it's admitted fact, my lord, that the original landowner was Mr. Sangreshu's clerk. And then it was.
The land was transferred to me.
My lord, here I am also a claimant, that I am one of the transferees, and my friend is also a claimant. So there is a dispute of a civil nature between the. So that aspect, my lord, I don't know what is the finding of the Honorable District Judge. Of course, my lord, if we get copies, then we can respond to that before your lordships also. That is also possible.
All right. That will be better. And
But-
please come up, each of you, with your considered submission with regard to this.
My lord.
Whether an appeal is to be preferred,
My lord.
or the court will simply adjourn this matter and give any person aggrieved to prefer an appeal and get some order which is contrary to this too.
Right.
And if nothing is got, then this will be rubber stamped.
But.
Copy of the order and the finding of the reference code may be made over this.
Who has a copy of the order?
Nobody is having, my lord.
It's only before your lordships. my lord.
Just before your lordship. Yeah, it is a report.
Further to our order dated 26 February 2025, the learned Special Judicial Officer, East Khasi Hills, Shillong, started LA case number 1 of 2025, comma, heard the parties extensively, and has passed a judgment and order on 28th June 2025. It is a long, detailed and extensive judgment. Full stop. The original judgment signed by the learned judge has been sent to the registry of this court and is in the file of this proceeding. We direct the Registrar General we direct the court master attached to this court to make photocopies of this judgment and order in adequate number and circulate them to all the parties. By 30th June. List this public interest litigation for further consideration on 3rd July.
3rd July. Madam.
Obliged, Your Lordship.
Obliged.
Okay.
Number 3.
List. Yes. Yes, please.
Yes, this is an appeal, my lords, by the Power Distribution Corporation against an order passed by the learned single judge, whereby, my lords, the learned single judge has passed an order directing regularization, my lords, of 2 employees, primarily on the basis that their clan had way back in 2015 transferred certain lands for the purposes of construction of a substation. And it is their case, my lords, that there was a verbal agreement at the time of transfer that 2 members will be given permanent employment in the corporation. On that basis, my lords, in 2024, the petitioners, my lords, instituted a writ petition, and which resulted, my lords, in culmination of an impugned order, my lords. So our case, my lords, as far as this appeal is concerned, my lords, is this, that firstly, as far as the transfer documents are concerned, there was nothing, no condition was made as part of the transfer to grant employment to any members of the clan. Secondly, my lords, they place reliance upon an office memorandum passed by the government of Meghalaya, which is inapplicable to the Power Corporation. And that too, that office memorandum was passed after the transfer had been effectuated. So the learned single judge places reliance upon that office memorandum, but that office memorandum is not applicable in this case. And lastly, my lords, the petitioners in the intervening period between 2015 and 2024 had accepted temporary appointment, contractual appointment. So by way of their own acts, they had, my lords, accepted the contractual employment, and now, my lords, it was our case that they cannot approach this honorable court for seeking regularization of service. So, my lords, that is a bird's eye view of the case.
Mr. Pandey, you are ready to proceed with this appeal?
My lords, I am ready to proceed with the matter, but there is one caveat that I may, my lords, inform this court. My lords, in the morning, I have received instructions from my client that the transfer document which had been placed before this honorable court by way of the writ petition, my lords, my client is saying, my lords, there is a subsequent document after that. And, my lords, in the interest of purity of the proceedings, my lords, it is my request, my lords, that document had to be placed, my lords, on the record of this honorable court.
What is the subsequent document?
My lords, there is a subsequent patta which has been executed, certain monies have been paid, and the clan has accepted that amount.
No, they have transferred to you.
They have transferred the land to me. Their case was that the land was transferred free of cost. Free of cost. But subsequently, there has been a subsequent patta.
So their case is transfer of land in lieu of that employment.
Yes.
So now your case is that they have received money, that thing about employment is oral, there is nothing in writing.
Yes.
And that they have received consideration.
Right.
I am not aware about this consideration aspect. If my friend has some fresh document, maybe he can place it on record, my lord. Because the only document we have shows that it was a donation. It was in the nature of a donation. But more importantly, my lord, I would humbly submit that the transfer of land is not really the issue here. It is that office memorandum of 2017, which is the crux of the matter, my lord. As per that office memorandum, whenever there is a donation of land for establishing some sort of public utility, 2 persons from the family, from the clan, have to be appointed, my lord. The appointment which I received in 2020 was not really a proper appointment. It was a contractual. Year on year, my contract had to be renewed. Over and above everything else, my lord, the case that I had placed for the learned single judge, and which is still before this honorable appellate forum, is a case based on Article 14, my lord. I am seeking parity with 20 other persons who were appointed 1 month prior to me, based on that office memorandum. Those 20 persons, my lord, their families had also donated land, and through operation of that office memorandum, they received proper employment, my lord.
So let us see whether it is donation or not.
My lord, that's my lord. He may put it on record, my lord.
Well, one more thing, just to add to that point of the negative equality which the petitioners are trying to seek. Even, my lords, I have received instructions as far as the other case is concerned, my lords, it's a completely different case. And there were certain commitments made in the public
We will hear that.
I will place that also, my lords. Along with this, I will place that.
Is item number 2.
3, my lord.
Mr. Pandey, learned advocate for the appellant. Submits. At the time of opening the appeal, that a very vital document is sought to be introduced by his client before this court, having a substantial bearing on the case. Full stop. He says that the document would show that there was in fact there was not any gift of the subject land by the respondents to the appellant, but that consideration passed for the transfer. Also, therefore, there was no basis to claim employment in lieu of gratis transfer of land. Full stop. We grant leave under Order 41, Rule 27 of the Civil Procedure Code to the appellant to bring on this document. By filing a supplementary paper book. By when, Mr. Pandey?
Lords may grant me 2 weeks, my lords.
Just one document, Mr.
Lords,
Take
1 week,
10
1 week, lords.
10 days.
10 days.
By 4th July, to enable this court to do complete justice between the parties. A copy of the supplementary paper book should be served upon advocate and record for the respondents. List this appeal for further hearing on 8th July.
My lords.
Obliged.
Obliged.
Number 4 to 7.
Ma'am's matter 8.
Yes, please.
Well, 4 to 7 are connected matters, my lord, arising out of the same common judgment and out part of the single judgment. But here the issue revolves around two aspects, my lord.
Yes.
My lord, the appellant before lordship is called Northeastern Center for Technology Application and Research, NECTAR in short, my lord. This is a scientific organization under the...
Both of you are ready to proceed with the appeal.
Yes.
Dr. Mozika?
As lordship, please, my lord.
No, not
Can be some other date also, my lord.
Why you are not ready today?
It will take some time, my lord. Therefore,
Do it tomorrow.
tomorrow.
Huh?
Tomorrow.
Issue is limited to a very small issue. Some appointments had been made. They say, well, it's the composition of the General Council who were to ratify was not in conformity. That has been.
Issue only is involved whether the appointment was made by the competent authority or not, my lord. Our case is, my lord, the governing council of this institution, my lord. That is the competent authority for making appointments. Here, the Director General, who is not competent, he made the appointments, my lord, and then he sent it for ratification to the governing council.
Post facto.
Post facto.
That has been.
Post
That has
facto was
been
not
approved.
granted.
That was
An
been-
inquiry was conducted, my lord. It was found that without exploring the other possibilities, my lord, they were given appointment. And
That's
that
been
also
negated by the learned single judge.
that is why we are before on the appeal, my lord. Learned single judge
Get
didn't
ready
accept
to do
that.
it tomorrow.
Tomorrow.
Tomorrow, let's.
All right. Heard and adjourned till tomorrow, bracket 25th, for further hearing.
Yes. Obliged.
Deeply.
Number 8 to 22.
Yes.
My lord, this is an appeal preferred by the state government, my lord. The matter came up on the 19th of May, my lord, whereby lordship has condoned the delay and directed the appellant to prepare the paper book and to make the necessary correction. So, my lord, I have filed the paper book as well as served the copy to my senior colleagues, my lord, yesterday as well as today, since there are two councils representing the respondents. So, my lord, all the direction of this lordship, we have already done it.
You are ready to proceed
My
with
lord,
the
I'm
bill?
praying this matter can come up after a week or something, my lord, since I have just served the copy to my seniors also just yesterday. And moreover, my lord, Advocate General will be leading this matter.
He is not asking for time.
My lord, I'm praying for time. Advocate General will be leading this matter since
Where
he's
is
out.
he?
My lord, he's in abroad, my lord. He has gone out of the country at present. So he'll be back by next
When
week.
is Supreme Court reopening?
My lord, I'm not aware, but most likely
You know.
from next week. Next week, my lord. Next week.
First week of July.
Huh?
Sometime
Next
first
week,
of
my
July.
lord.
First week.
15th of July, my lord.
The Supreme Court is reopening on the 15th, my lords.
15th.
15th. And this time around, my lords, the Supreme Court has introduced partial court working days. So, partially it has been functioning, but the Supreme Court has...
No, that is taken as vacation benches.
Vacation,
but 15th July.
15th July. Yes.
When do you want it?
Well, it can be, my lords, in the first week of July. So
Advocate General will be back.
He'll be back, my lords, by then.
All right, by consent of learned counsel for the parties, list these appeals on 9 July.
Obligation.